Namaskar. In the previous lesson, we tried to analyze the working of the first special enactment dealing with the consumer protection in India, that is the Consumer Protection Act of 1986. This particular act, which was in force for about 34 years, has been replaced by the new Consumer Protection Act 2019, and this act deals with some of the emerging issues in the area of consumer protection. This law is the culmination of number of efforts which started in 2015, 2018 and 2019. The new Act of 2019 has been enacted by the Parliament, and it received the presidential assent on 9th August 2019. The new Act came into force from 20th July 2020. On 23rd July 2020, the central government notified further provisions in relation to the Central Consumer Protection Authority CCPA, which came into force from 24th July 2020. When we look at the object of this enactment, it can be seen that they include the object to provide for protection of the interests of consumers, and for the said purpose to establish authorities for timely and effective administration and settlement of consumers' disputes. In other words, the new Act envisaged setting up of new authorities probably more effective than the consumer protection councils under the repealed Act of 1986. The new legislation is a very comprehensive legislation consisting of 107 sections. If we compare the old Act of 1986, there used to be only 31 sections. Similarly, as many new concepts have emerged in the area of consumer protection, the new law contains as many as 47 definitions as compared to 23 definitions under the old law of 1986. The new definitions, which are numerous, include advertisement, central authority, consumer rights, design, direct selling, director general, e-commerce, electronic service provider, endorsement, express warranty, harm, injury, mediation, mediator, misleading advertisement, product, product liability action, product manufacturer, product seller, product service provider, regulator and unfair contract. This list is only illustrative in nature, but some critics say that there are too many definitions incorporated under the new Act of 2019. When we look at the consumer rights, the new Act defines consumer rights, including the right to be protected against the marketing of goods, products or services which are hazardous to life and property, that is right to safety, the right to be informed about the quality, quantity, potency, purity, standard and price of goods, products or services as the case may be, so as to protect the consumer against unfair trade practices, that is right to information. the right to be assured wherever possible access to variety of goods, products or services at competitive prices, that is the right to access to variety of goods and services, the right to be heard and to be assured that consumers' interests will receive due consideration at appropriate fora, that is the right to be heard, the right to seek redressal against unfair trade practices or restrictive trade practices or unscrupulous exploitation of consumers, that is right to redressal, and the right to consumer awareness. In fact, whatever had been the objects of the Consumer Protection Councils under section 6 of the repealed Act of 1986 appear to have been incorporated in the definition of consumer rights under the new Act. Another salient feature of the Consumer Protection Act 2019 is the establishment of Central Consumer Protection Authority CCPA, which is dealt with under chapter 3 and sections 10 to 27 of the Act. In fact, this authority is envisaged to be a super regulatory authority in respect of the consumer rights, unfair trade practices and false and misleading advertisements, so on and so forth. The Act also envisages the provision for establishment of regional offices. The main object of the establishment of CCPA is to promote, protect and enforce rights of consumers as a class, and the authority is to consist of a chief commissioner and other commissioners. The number is yet to be fixed, and the CCPA is empowered to engage professionals and experts to assist in discharge of its functions, and there is a separate provision for investigation in the form of investigation wing headed by Director General, etc. And continuing with the powers and functions of the central authority, they include the protection, promotion and enforcement of rights of consumers as a class, and for the purpose of preventing violation of consumer rights, the prevention of unfair trade practices, the prohibition of misleading advertisements relating to goods and services, the prohibition of publication of false and misleading advertisements, to inquire or investigate violations of consumer rights, unfair trade practices either suo motu, that is on its own, or on a complaint received or on directions from central government, to file complaints before the district forum, state forum and national forum, or intervene in proceedings before them, to issue safety notices to alert consumers, to undertake and promote research on consumer rights, to spread and promote awareness on consumer rights, etc. The CCPA is also empowered to recall goods or direct the withdrawal of services or reimbursement of prices of goods and services in certain cases, and to give directions to traders, manufacturers, endorsers, advertisers and publishers to discontinue the false and misleading advertisements, to impose penalties on manufacturers and endorsers ranging from maximum rupees 10 lakhs to 50 lakhs, apart from imposing imprisonment under section 21 of the Act, to conduct search and seizure and to return goods, etc., which are seized within 20 days. It is interesting to note that all the orders passed by the CCPA are made appealable to the National Commission within 30 days, and any non-compliance with the directions of CCPA is made punishable with imprisonment up to 6 months or with a fine up to rupees 20 lakhs or with both. Another notable feature of the Consumer Protection Act of 2019 is that the district collectors are empowered under the new law dealing with the consumer protection. Under section 16 of the Act, the district collector may, on a complaint or on a reference made to him by central authority or the commissioner of a regional office of the central authority, inquire into or investigate complaints regarding violation of rights of consumers as a class, on matters relating to violation of consumer rights, unfair trade practices and false or misleading advertisements within his jurisdiction, and to submit his report to the central authority or to the commissioner of a regional office as the case may be. And a good feature is that the district collector may also receive any complaint online also. Another striking feature of the 2019 Act is the introduction of the mediation process. The Act envisages establishment of consumer mediation cells. Under section 74 of the Act, the state government shall establish a consumer mediation cell to be attached to each of the district commissions and the state commissions of that state. The central government shall establish a consumer mediation cell to be attached to the national commission and each of the regional benches. The reference to mediation by the district forum is provided under section 37. This provision says that at the first hearing of the complaint after its admission or at any later stage, if it appears to the district commission that there exists elements of a settlement which may be acceptable to the parties, except in such cases as may be prescribed, it may direct the parties to give in writing within 5 days the consent to have their dispute settled by mediation in accordance with the provisions of chapter 5, and the other relevant sections are section 74 to 81. Those with legal background may understand that there is a similar provision with regard to civil suits which are filed in civil courts under the Code of Civil Procedure 1908. Section 89 of Civil Procedure Code employs almost a similar language which is used in the new Consumer Protection Act of 2019. And in case there is a failure of mediation, it is needless to mention that the complainant may proceed with each complaint as if there is no settlement outside the commission. And many experts believe that the success of the mediation process lies in making the proper rules and in identifying the proper mediators. And the new enactment of 2019 made certain other significant changes. For instance, there is a provision for online complaints and notices through electronic service provider. There is a provision for taking expert assistance in case of the National Commission under section 66. Then there is a notable enhancement of pecuniary jurisdiction of the district commission, that is up to maximum 1 crore, the state commission, that is more than 1 crore and up to 10 crores, and the national commission more than 10 crores. It is also equally important to see that the district forum has been renamed as district commission. So, now there are 3 commissions: district commission, state commission and national commission. And there is a special provision under section 72 dealing with the penalties for non-compliance with the orders passed by the district commission, state commission and national commission. And the penalties include minimum 3 months imprisonment and maximum 3 years imprisonment, and the fine may be minimum rupees 25,000 and maximum 1 lakh. And yet another very important change in the new law is the incorporation of the product liability related provisions, which were conspicuously missing in the Consumer Protection Act of 1986. There are 6 sections which deal with the product liability related provisions in the form of sections 82 to 87, and there is also a separate set of provisions under the heading offences and penalties explained in sections 88 to 92. And there are number of measures which can be taken to prevent unfair trade practices in e-commerce and the direct selling etc. under section 94. With a view to give a second chance to the traders and others to rectify their errors or to undo their mistakes, there is a provision for the compoundability of certain offences for non-compliance with the directions given by CCPA and also for false and misleading advertisements. The Act made certain welcome provisions. For instance, a very powerful authority in the form of CCPA has been established. Then, in the age of alternative dispute resolution, there is a provision for mediation process at the district level, state commission level and national commission level. There has been an introduction of the product liability, which was implicit under the previous act. There is a prohibition of false and misleading advertisements, a special provision has been made. And another important point, the celebrities, whoever makes false endorsements and advertisements, now they come under the scanner of law, and there is a prohibition of false advertisements and false endorsements by celebrities. And the punishments I have already mentioned, there are number of provisions relating to punishments. For example, under section 89, any manufacturer or service provider who causes a false or misleading advertisement to be made which is prejudicial to the interest of consumers shall be punished with imprisonment for a term which may extend up to 2 years and with fine which may extend to 10 lakh rupees, and for every subsequent offence be punished with imprisonment for a term which may extend to 5 years and with fine which may extend to 50 lakh rupees. Indeed, the punitive provisions are quite stringent. Now, to take advantage of the information and communication technology, the concept of e-filing and e-notice mechanism has been introduced under the new act. There is also a provision for engagement of professionals and experts, so that the consumer disputes could be settled in an amicable and effective manner. So, what was implicit under section 13 clause 4 of the old act is now specifically guaranteed under section 38 clause 9 subclause D, especially for National Commission under section 66. The new act, though is very progressive, also contains a few debatable provisions which may be a relative opinion. For example, people complain about the large number of provisions of the act, 107 sections. In fact, if the law is simple, probably enforcement also may be simple. Another criticism is that there are too many authorities which are envisaged under the new act, the CCPA, Consumer Protection Councils, even the role assigned to the district collector, etc. Then there is introduction of formalism in the resolution process. So, again the formalism in the form of not only following the principles of natural justice, but other requirements may not be welcomed, and there are too many definitions. Every time a person wants to ventilate his grievances, then they have to look at these definitions, and there is a likelihood of confusion between the rules made by different authorities or sources. For instance, rules of central government made under section 101, state government under section 102, and regulations of CCPA under section 104 and of the National Commission under section 103. So, there is a likelihood of confusion between these rules and regulations. There is yet another one, requirement of deposit of 50% amount directed to be paid while appealing to the state commission or national commission. This provision is under section 41 and 51 of the new act respectively, but there appears to be no discretion for the appellate commissions to reduce the 50% amount to be deposited for preferring an appeal. Though the Supreme Court has commented on the purpose of this 50% minimum deposit, this appears to be a little unreasonable in view of the uneven or unequal economic power in the common man, the consumer on one hand and the trader on the other hand. Similarly, the power to set ex parte orders is given only to few authorities. Then there is a deletion of a provision which is similar to section 26 under the old act. In fact, section 26 was to protect the genuine traders or service providers, especially when there was some kind of vexatious or frivolous complaint, but unfortunately under the new act there is no similar provision. So, even if somebody misuses the mechanism under the new act of 2019, there is no deterrence. This is one important aspect. Now, coming to the relevant regulations, as pointed out a few minutes back, number of regulations have been made. For instance, the Consumer Protection Consumer Commission Procedure Regulations 2020, they are made by National Commission. The Consumer Protection Mediation Regulations 2020, they are also made by National Commission. Central Consumer Protection Authority Allocation and Transaction of Business Regulations 2020, then Consumer Protection Qualification for Appointment, Method of Recruitment, Procedure of Appointment, Term of Office, Resignation and Removal of the President and Members of the State Commission and District Commission Rules 2020, they are made by the central government, and the Consumer Protection E-Commerce Rules 2020 made by the central government. Thus, there appears to be a little scope for confusion with regard to the application and scope of all these rules and regulations made by different authorities. And the courts in India are slowly equipping themselves. The consumer commissions are gearing up to deal with the new Consumer Protection Act of 2019. And today there are number of cases which are decided by the Supreme Court also with regard to unfair contracts under the new Consumer Protection Act, the deficiency under the Carriers Act, the advertisements by trade rivals, and in one of the judgments delivered in March 2021, the Supreme Court dealt with the operational effect of the Consumer Protection Act 2019, and the court emphatically said that the proceedings instituted before the commencement of the Act of 2019 on 20th July 2020 would continue before the fora corresponding to those under the Act of 1986, that is the National Commission, State Commission and District Forum, and it should not be transferred in terms of the pecuniary jurisdiction set for the fora established under the new Act of 2019. This is another important aspect. So, similarly, we have the other related cases relating to the prohibition of consumers from joining together and filing joint complaints, but subject to certain technical issues. The Supreme Court addressed this issue in a case called Brigade Enterprises Limited versus Anil Kumar Veermani in December 2021. However, the interesting times seem to be ahead. The Act is comprehensive. If there are any rough spots, they can be ironed out, and the Act, if purposively used and interpreted, will definitely help the consumers at large. I hope that you have enjoyed the lesson as far as the salient features of the new Act of 2019 is concerned. We shall meet in the next lesson. Thank you.